Mr. Farias, you're charged with two cases. You're charged with driving while intoxicated. You're also charged with assault of a family member. You're facing up to a year on the assault case and or a $4,000 fine. And on the DWI, you're facing up to 6 months in jail and or a $2,000 fine. What have you guys worked out?
So for he's pleading time served on the DWI.
This plea deal is already setting the stage for major consequences. The DWI carries time served, but the assault case is deferred, which essentially means probation with strict conditions. One mistake, and the full penalty comes crashing down. So, while it might look like mercy, the judge is really putting the defendant on a razor-thin leash. The question is, should deferred agreements allow more forgiveness? Or are they really just traps waiting to snap shut?
13 months deferred on the assault conditions.
Okay. Is this how you understand this agreement?
I'm sorry.
You have two agreements on both of your cases. On the DWI, they've offered you 3 days in jail, credit for the 5 days that you've done. But you need to understand that charge will go on your record. It's going to be there for the rest of your life. From now on, you are facing a minimum of 30 days in jail. So this time served, it's a minimum of 30 days in jail. Anytime you get pulled over, an officer's going to look at your record. They're going to see this. What do you think they're going to do if you smell like alcohol or dope? Right. I would never, even if you've had a sip of alcohol, I would not get into a car because it is a humongous risk. As far as the assault of a family member is concerned, you've worked out an agreement. They're offering you a 13-month deferred. Deferred is a type of probation that if you successfully complete it, you do not end up with a conviction on your record. You must understand, though, that this comes with an affirmative finding of family violence, meaning that if you ever pick up another one of these cases, even if you successfully complete the deferred, you will be looking at a third-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. You can also never own a gun or ammunition as well. You will be signing this other piece of...
This is a major delay with serious consequences. An affirmative finding of family violence stays on the record even if the case is deferred and automatically bans someone from owning guns or ammunition. That means a single slip-up, even years later, can turn a misdemeanor into a felony with prison time. The law treats family violence like a multiplier. Once it's there, every charge after hits harder. Imagine being just 20 and losing the right to ever own a firearm. Should that restriction be permanent, or should people have a chance to earn it back?
Behavior here, which is a written admonition that you are ineligible to possess a firearm or ammunition as a result of this plea bargain agreement as well. What you need to understand, it's firearm is a very loose term. So you need to understand, if you don't understand what a firearm is or what a weapon is, you need to talk to a lawyer because that's one of the conditions. Do you understand? When you pick up criminal cases, there are a lot of collateral consequences, as you now see. It can impact you in ways that you never, ever see. That's why you need to strive to never pick up any kind of cases. And when you pick up multiple successive cases, it kills you. And now you're ending up with these things, with both of these. Anytime you come into a contact with an officer and they look at your record, you think that you'll get the benefit of the doubt. Be careful. Just, that's all I'm going to tell you is be careful. Now, part of the agreement on the deferred, you need to also understand you give up nearly every right known to man by entering this agreement. If you fail to live up to the terms of this agreement, we will issue a warrant for your arrest, put you in jail, and now you're looking at an entire year that you authorize to put you in custody if you violate this. You understand? For you to complete this successfully, you have to do a Batters Intervention Prevention Program, what's called a BIP class. This is a 15-week, I'm sorry, is it it's 18, right? 18-week class that you have to go to one time a week for 8. You don't have to do this. We can set your cases for trial if you don't want to do this. Well, look, if you have that kind of attitude and you go into it,
Have attitude, Judge, is just, I mean, I understand, I messed up. I messed up. It's no one's fault but mine. I understand that, but y'all really treated me like I'm constantly getting in trouble for it. I'm not. I mean, I understand. I got a DUI and I ended up catching another.
criminal court, did you think this was going to be rainbows and gumdrops?
No, I didn't think that. I'm just, it's just.
And here's the thing though, Mr. Faris, what you need to understand is if you think it was bad here, that's what you're saying to me now. If you think it's bad now, wait till you get out there in the free world with even more conviction on your record. Life will only get more difficult with the more convictions that you get.
I hadn't been getting in trouble for the past year. I got that DUI in 2020. I have not been in trouble for it since then. So y'all treating me like if I'm constantly getting in trouble for it. And I'm not trying to be rude. I'm really not.
How did we treat you that you're constantly in trouble? Tell me.
It's a conversation.
No, but Nathan, I want him. How did we treat you in what way?
I mean, I'm not
Tell
saying
me.
y'all treating me in any way. It's just like the way you talk to me. I have like I'm just a hardened criminal. All I did was I was young. I made a mistake. I was 20. I made a mistake. I was drinking. It was just a mistake.
Please do not admit to committing the offenses. We actually haven't been found guilty yet.
You mean how I'm talking to you right now?
Yes, sir.
I'm telling you what to expect.
And I understand that,
And I'm
but
telling you how it's going to affect you.
and I understand that.
And I'm telling you that you can't own a gun.
That's fine. No problem.
You can't own any ammunition.
That is fine. No problem whatsoever.
If you pick up another assault like this, you're looking at 2 to 10 in the penitentiary.
See, but I didn't assault nobody, but I
You're pleading
understand.
guilty to assaulting.
But I understand.
You're-
I'm not going to take your agreement. If you're telling me you're not guilty, then we're not going to do it.
That's how this works. You're pleading guilty and admitting that you committed a crime.
Okay.
If you stand up here and say that you didn't commit a crime,
No,
then
no,
you're not pleading
this
guilty.
isn't like, it's not a game. And I'm not going to let you
Understand that.
plead guilty if you're not guilty. If you're not guilty, then let's try it. I'm not taking your plea of guilty if you're not guilty. That's it.
At this point, I politely request that we reset this case, short distance, have the client's appearance be required.
Well, hold on a second. How old is the case? I mean, the case.
Here's the turning point. The defendant claims he's reformed, but the judge isn't convinced, and the record makes it clear why. In the legal system, patterns carry weight. A single mistake might earn leniency, but when years go by and new charges keep surfacing, credibility disappears. That raises a real question. Should judges focus more on rehabilitation, or does a repeated pattern of reoffending prove that leniency only backfires?
This is from 20, it's 510 days old. No, we set the case for trial today. That's it. And I'm not here to play games. If you're either guilty or you're not guilty, but we don't plead people guilty when they're not guilty. That's not a game that we play here. And understand the way I talk to you now is in hopes that you don't pick anything up in the future, because
I haven't.
do you know how many times I hear that?
I'm pretty sure you hear it on an everyday basis. I'm
Every
sure you do.
single-
But I am one of those persons that means it when he says it.
I'm going to hit the pause button.
You
This-
pick up a case in 2020, and now you pick up a case in 2023.
I'm going to hit the pause button here. What you're getting upset about is actually the language that the judge is required to say. He's not admonishing you about anything special about your case. He doesn't care anything about you. But what you're pleading guilty to
No,
carries
you're-
with it these consequences.
I understand.
If you plead guilty to an assault family violence, there's an affirmative finding of family violence, as was explained to you. A second offense is automatically a third-degree felony. Third-degree felony punishment range is 2 to 10. If it's a strangulation, it's now 2 to 20 because it's a second-degree felony. This is automatic, has nothing to do with you, only has to do with what you're pleading guilty to. The DWI is similar in concept. If you plead guilty to DWI today and get convicted, which is what you're planning on doing, the second one is automatically a Class A misdemeanor with a maximum punishment of a year in county or a $4,000 fine. That has nothing to do with the facts of your case and your level of guilt. It's just the fact that you are pleading guilty. At the same time, I don't like this conversation. We're walking away, and we're going to have a later court date. So you go over here.
So if you want to continue on the DWI and tee up the assault, we can do that as well.
No, Judge. With him, we're not doing any pleas. At your request, we'll set the case for trial. I'd ask for 30 days. I'll have a conversation with
Totally.
him. And if he wants to do the plea, we can do the plea. And he will come up here with the proper understanding.
It's not a big deal, but we either set it today or we,
Oh, I'll just set it today because it'll be long enough that we can have a conversation. Almost
So-
30 or so days, Judge.
yeah, November 19th.
That's
That's,
fine.
it's over 30 days.
Yeah.
Okay.
It's not that, it's just that I don't remember when Thanksgiving is. Which is a week or two after that, so we're fine.
It's that Tuesday. So it's the Tuesday before.
Tuesday, the week before,
Correct.
we're fine.
Okay, 11/19 it is on
I
both
like it.
cases.
Is Ramona in the back? Do I need to go talk to her?
Yes, no. Good morning, ma'am. Ma'am, you were charged with theft. You're facing up to 6 months in jail and or $2,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On September 8th, 2024, an officer was dispatched to a target in Harris County, Texas regarding a theft. Upon arrival, the officer met with the complainant, the loss prevention manager, who advised the defendant had stolen from the business. The complainant advised that the defendant had entered the business with no merchandise and with a small pink fanny pack on her person. The defendant was then observed going to the style department and began making selections at the merchandise and then began going into the business fitting room. The defendant exited the fitting room and the style merchandise was not seen, and the defendant dumped the merchandise on the rack in the fitting room. The defendant was then observed going to the jewelry department, and the complainant advised the defendant was observed quickly selecting Kendra Scott jewelry, and the defendant went to the beauty department and was advised that she began selecting Kendra Scott jewelry and hair care department merchandise. And the defendant then went to the home department and then the chemical aisle and began concealing merchandise into the small pink fanny pack and began walking towards the front of the store. The defendant passed all points of sale without rendering payment for the items, and the total amount taken was $103.92
Okay, where did you say this is from?
at Target.
Got it. Okay. Ms. De La Cruz, I'm going to find that there's probable cause to go forward with your case. How old are you, ma'am?
19.
What do you do for a living?
I go to school,
Where do you go to school?
Pima Medical Institute.
Okay. Are you working as well?
Not currently.
Who do you live with?
My parents.
Are they here today with you? Okay. Like I said, I'm going to find probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to go to any Target stores whatsoever. You were given a free bond, so we let you out of jail. And that's how you're here before me. You're not going to get another one. If you pick up a new case, if you go to any Target or do something you're not supposed to, I will revoke the bond, put you in jail. You will not get any more PR bonds, and it's going to go way higher than it is now. Do you understand? Did you want to apply for a court-appointed lawyer, ma'am? Okay, we will give you an application. I'm going to have you go to Victoria, sign a reset. After that, we'll have you take a seat in the jury box. Do not leave until you sign our bond conditions, though. Okay?
Where do I go for it?
First, we're going to have you sign a reset, and then we need to give you an application for an appointed lawyer. I need to know everything about you, and then we'll have you take a seat in the jury box. Please. Good morning, Mr. Javed.
Good morning.
Sir, you're charged with terroristic threat or a family or a household member. That allegation kicks it up to a Class A misdemeanor, so you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On October 8th, 2024, in Harris County, Texas, an officer was dispatched to meet with a firefighter at 3515, a residence in Harris County, Texas. The officer met with the complainant, who stated she got into an argument with her husband, the defendant. The complainant stated the defendant had been threatening to kill the complainant's family in Pakistan and to kill her in the past. In 2023, she called the police, but no report was made because she was afraid of retaliation. The complainant stated they have talked about who the defendant knows in Pakistan and believed the defendant could do something to her family to have them killed. The complainant stated the defendant made these threats to her and her family to control her. When the complainant called for police on October 8th, the defendant told the complainant if she called the police, the complainant knew the consequences, while making a circle in his hands, gesturing as if to strangle the complainant.
So there's also felony retaliation.
Yes, Your Honor.
Is this within what you just said now, or is it something else that happened? Because I know it arises out of the same, but was there any more overt action that was done other than spoken word?
Sorry, Your Honor, let me check the DIMS.
Mr. Javed, I'm going to find that there's probable cause to go forward with your case. Tell me, are you a United States citizen?
Yes, yes, sir.
I'm ordering you as a condition of your bond not to have any contact with this complaining witness. Do you understand?
Yes, sir.
I'm entering in, or it looks like a protective order has already been issued on the 9th of this month. I would get to know it. If you do something to violate this protective order, the state can and will file additional charges as violation of protective order. And I'm telling you, that's one of the worst cases you can pick up. You violate conditions on a no contact order, I can hold you at zero bond. And I will do it in a second to protect every person of Harris County. Do you understand?
Yes, sir.
When I mean no contact, I mean no contact of any kind. Phone calls, text messages, social media, use of another person to relay any information. I'm also ordering you as a condition of your bond not to be in possession of weapons. Do you understand?
Yes, sir.
If you violate these conditions, I will revoke your bond. I'm going to put you in jail. You will not get any more PR bonds. And I'm telling you now, I'm going to make it high. So no contact of any kind.
Your Honor, appears to be just the verbal threats.
Okay. So can you file no contact and no weapons, please?
Yes, Your Honor.
For now, I'm going to have you sign a reset with Victoria. After that, we'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign the bond conditions, and then we'll have you wait for your lawyer. Okay? Please.
All right, page 12. Go ahead and sign the consent.
Mr. Dakota, do you have an arraignment?
No, sir.
No? Okay.
Cubone? All right, Judge, page 19, Perkins, come on up.
Silence all cell phones.
Good morning, Ms. Perkins. Ma'am, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. So you are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On October 9th, 2024, officers were dispatched to 5299 West Park Drive in Harris County, Texas, regarding a major crash. The will witness stated he saw the defendant get out of the driver's seat of her motor vehicle, and Houston Fire Department advised the defendant admitted to drinking. The officers observed the defendant with slurred speech and glassy eyes. Standard field sobriety tests were conducted. HGN was 6 out of 6, walk and turn of 3 out of 8, and one leg stand was 2 out of 4. The DIC was read and the defendant consented to breath. The results were 0.153 and 0.157.
Tell me about the driving facts again, please.
There was a major crash, Your Honor.
Okay, so she's at a crash.
She's at a crash, and then the real witness who was involved in the crash saw the defendant get out of the driver's side.
Got it. Okay. Ms. Perkins, I'm going to find that there's probable cause to go forward with the case. Do you have a valid Texas driver license, ma'am? Do you have valid liability insurance in your name? Can you run the license, please?
Yes,
And
Your Honor.
also, does she have any prior DWIs, please? If you can
No
run
prior
your
DWI
license.
and license eligible.
Okay, ma'am, I'm going to find, like I said, there's probable cause to go forward. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or any kind of illegal drugs, I will put you in jail. I'm going to revoke your bond. You will not get any more PR bonds. Do you understand? How old are you, ma'am? You're 20. What do you do for a living? Where do you work? Mom shells. Who do you live with? No, with mom, dad, or by yourself? Okay. Can you afford a lawyer? How much money do you make a month? Okay. Is that all you're doing now, or are you doing anything else in school or anything? Okay, I'll have you. Let me see. You to fill out an application for me for an appointed lawyer, and I'll take a look at it. If you qualify, I'll provide you with a lawyer today. For now, I'm going to have you go to Victoria, sign a reset. After that, we'll have you take a seat in the jury box while you fill out the application, then I'll take a look at it. Okay? You will need to meet with the pre-trial for your bond conditions, so don't leave until you do that. Okay? please. You have an arraignment. Are you ready?
I do.
We have to do it right.
Yeah.
Whenever you're ready.
Yes, we have another arrangement.
You want to do Corey's first or?
Is that arrangement?
Yeah.
Oh, who was it?
Cubone.
Oh, that's the one else.
Is it Cubone?
It's fresh.
I'm not exactly sure how to pronounce it.
How do we pronounce your name, ma'am? Cubone. Ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. Okay?
Yes, Judge. On September 18, 2024, the officer was dispatched to a Walmart in reference to a theft in Harris County, Texas. The officer made contact with the loss prevention manager, who stated he followed the defendant in pink nurse scrubs within the business as she was pushing a shopping cart and concealing in a black backpack several items she took from the shelves of the business. The defendant observed the defendant pay for the items in the cart at the self-checkout, pass all points of sale, and exit without paying for the items she had loaded in the backpack. The complainant stopped the defendant outside the exit doors and confronted her about the concealed items. The defendant initially denied everything, but ultimately gave her the backpack, to which the defendant found unpaid items with a value of $118.53. Another unpaid item of a value of $1.38 was found wrapped in a Walmart plastic bag in the shopping cart. The total amount taken was $119.91.
Okay. All right, ma'am, I'm going to find that there's probable cause to go forward with your case. Tell me, are you a United States citizen? You are? Okay, I am ordering you as a condition of your bond not to go back to any Walmart. If we find that you go back to Walmart, I will revoke your bond, put you in jail. You will not get any more PR bonds. Do you understand? Okay. You have a lawyer. Because you have a lawyer, I will waive your appearance. So you don't have to come to court until he tells you that your presence is needed. But you must stay in contact with Corey. If he tells me he can't get a hold of you because you're ducking and dodging phone calls, that's it. We will revoke your bond, okay? Any questions? Yeah, I know. I have to apprise you.
Understand, yeah.
Do you have any questions? Okay, we're gonna have you sign a reset. After that, we'll have you take a seat in the jury box. We get your bond condition. We'll have you sign it, and then you're free to go. Okay?
Thank you,
Okay,
Judge.
guys. Thanks, Corey.
Appreciate it.
Where's the slip?
And it is no, it says 3 days Harris County Jail. I spoke with the state. It is the time, sir.
Good morning, Mr. Reyes. Sir, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 3 days in jail, credit for the 1 day that you've done. You need to understand, sir, that this charge will go on your record. It's going to be there for the rest of your life. It's even there after you die. And this is important because you ever get pulled over and an officer's going to see this. If they smell alcohol or dope, what do you think they're going to do? What we're doing today, the proverbial slap on the wrist, now you'll be facing a minimum of 90 days in jail. So be careful because this time served, you understand. I mean, it's a minimum of 90 from now on. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, or possible immigration consequences, you can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you can never change this or undo this. It will go on your record. It will be there forever. Is this what you want to do?
Sir.
How do you plead to the offense, sir? Guilty or not guilty? I will find you guilty and I will sentence you to 3 days in jail. I'll give you credit for the 1 day that you've done. I have to suspend your license, so I will suspend it for 90 days. Do not drive until you get a license, and good luck to you, sir.
Judge, I asked that his license not be suspended. It's been suspended for over 220 days already.
I have to suspend it, right? If you want credit for the ALR suspension,
Yes, sir.
why has it been suspended for so long?
I am not very sure. He just spoke. I'm filling in for Attorney Clay today, Eric Clay. So I just spoke to the client about the suspension.
Part of my PR bond was not to drive, and you revoked my privilege to drive. So I've been.
Well, there's a reason. Usually, if you don't have a license, you don't have insurance.
Over a .15.
No, I never take someone's. Has to have been an aggravating factor as to why. I don't just willy-nilly take someone's ability to drive away because I take it really seriously. You know, if you're driving in a manner like going over 100 or a prior DWI or with an open container or something like that, What happened in this case, Alex?
Sorry, So in this case, officers were dispatched to a crash in Harris County, Texas, and they arrived and observed the vehicle with front end damage that had hit an apartment complex entrance gate and wall
You
building.
have a license.
I had a license, valid license and valid, liability.
See.
Part of my bond was, just suspended my license, I couldn't drive.
Oh, you know what it was? You had an ALR suspension. That's one. Your license was suspended. Have you paid any kind of reinstatement fees? Then your license is suspended now. Whenever you get a DWI, you have two cases against you. You have this case, you also have an administrative case versus DPS. And if you don't take care of the administrative case, DPS suspends your license and it remains in suspension until you go and actively take care of it to have it reinstated. One of those things that you have to do is pay a reinstatement fee of around $125. So until you do that, it remains effectively suspended indefinitely until you take care of it. What we do is we bring you back in to apprise you of the fact that your license does become suspended and that if you drive, you're in violation of these bond conditions. So I'm trying to help you, believe it or not. You know, I'm not. So do this. Go get your license reinstated. Go to DPS. Show me that you've got it reinstated. Then we can run so that I'll give you credit for the time that you've had your ALR suspension. I'd rather have you driving legally than, driving illegally, right? So go get it reinstated because what we need are the dates of suspension for the ALR. If you have that, we can give it to them and give you the credit.
Yes, sir.
But don't just start driving now. Your license is still suspended. Alex, can you run it? You mind?
Yes, Your Honor, it's not eligible. And the most recent we have is the ALR suspension.
See? It's the administrative license revocation suspension that you get from DPS. You got to go call DPS and they'll tell you what to do to get it reinstated. All right?
Thank you, Judge.
Okay, guys.
May be excused.
Thank you.
Please. Hey, apellido? Macero.
Page 14, Your Honor.
Thanks. Mr. Macero, you're charged with failure to identify oneself, giving false or fictitious information. You are facing up to 6 months in jail and/or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to an attorney. If you cannot afford one, one will be appointed to you.
All right, may I just get a cause number for that real quick?
It's 2533067.
On October 8th, 2024, the officer observed the defendant's motor vehicle fail to stop at a stop sign. A traffic stop was initiated. The officer made contact with the defendant. The defendant stated he did not have a driver's license, ID, or passport. The defendant wrote Jesus Gutierrez, date of birth October 2nd, 1977, on a notepad provided by the officer. There was no TCIC return for the name. The officer observed the defendant's motor vehicle to have a different VIN from that on TCIC, and the defendant consented to a search of the motor vehicle. The officer found a Venezuelan passport with the defendant's photograph and the name Jairo Jose Macero Barcenas, date of birth January 11th, 1976. The defendant stated he lied about the name to the officer and used a fake name because he was afraid and had never been stopped by officers while in the country.
Mr. Macero Barcenas.
Your Honor, he has to go to the civil trial.
Yeah, go. Thanks, Luis.
Hola, buenos días, me llamo Luis Lendarte. Disculpe la interrupción, mi colega se tiene que ir a un juicio. Acérquese aquí, por favor. Sobre el juez y conteste nada más en español. Hello.
Marcelo Barcenas, I'm going to find that there's probable cause to go forward with your case. Are you a United States citizen?
What?
Are you a United States citizen?
¿Estadounidense?
No.
No.
Are you in this country with or without permission?
¿Es con permiso o sin permiso? Sin permiso. Without permission.
I'm going to give you a warning now that if you go to jail and immigration finds you, they will put an immigration detainer on you You will remain in custody until this case is over with, and then you will be shipped off to immigration, and you will sit in immigration custody until they do whatever they're going to do to you. That usually is a process that'll take about 6 to 9 months. If you do not want that to happen, do not violate any of the conditions that I put on you now. Because if you do, you could be spending a lot of time in custody. You do not have a Texas driver license, so you are not allowed to drive. I am making that a condition of your bond. The other condition I'm putting now is not to get in trouble or violate any laws. You were able, I don't know if you went to jail, but from now on, you will not be given any more PR bonds. So your bonds will be sufficiently high that you're going to spend some time there. And if you're unlucky enough, immigration will put a detainer on you. You will get no further warnings. Do you understand?
Sí, señor. Tiene que hablar, sí, señor, o no, señor. Yes, sir.
No driving whatsoever.
Manejo para nada, no puede manejar.
Okay. We are going to reset your case to give you time to hire a lawyer. First, I will have you come up here, swear to us that you're not going to drive. After that, I will get you to Victoria, where we will have you sign a reset, and we're going to get you out of here. These are the only conditions I'm putting on you now. Don't drive and don't get in trouble. When you come back, please have a lawyer, sir.